Environmental problems are often complex problems, and often the solutions depend on cross-disciplinary collaborations. Collaboration itself is a complex system of people, theories and cultures, and collaboration must be preceded by a phase of collective thinking that creates shared conceptual frameworks. Collective thinking in a cross-disciplinary setting depends on collaborators that learn and understand each other's perspectives. And this really was the motivation for today's lecture and tomorrow's workshop, where we're going to bring together people, you people, to explore the gaps between environmental science and environmental law and try and build some bridges. Let me introduce Professor Nicolas Desaguliers, Professor of Law at St. Louis University in Brussels. Since 2010, Professor Desaguliers has held the Jean Monnet Chair in Trade and Environmental Conflict, sponsored by the European Commission. He plays an active role in debates on European Union legal and institutional issues, and he has previously held the Marie Curie Chair in Risk Assessment and Risk Management at the Faculty of Law at the University of Oslo. In Australia, he is most well known for two very impressive books: Environmental Principles, Political Slogans to Legal Rules. Although these are primarily focused on environmental law at the European Union level, his book has great relevance to international environmental law and national law systems in all developed countries. And the second one, Implementing the Precautionary Principles, which is also the focus of today's presentation, titled Bridges Between Environmental Science and Environmental Law. Please welcome Professor Nicolas Desaguliers.
It's an honor to be back in Canberra. I came here 8 years ago to deliver a speech at ANU during the course of a trip across Australia. And I was reminded to keep my French accent on the account that it was so beautiful. And that was told to me not in Canberra but in Melbourne. So I'm afraid that my accent didn't change in the course of these last 8 years, and you will have to cope with it. I'll start my speech in focusing on the importance the scientists are playing in the environmental legal field. And I will start to quote an environmental Australian lawyer, Gary Bates, who is quite famous in your country for main textbooks, 745 pages textbooks on Australian environmental law. And Mr. Bates is stressing that of all influences that determine environmental policy, none is more compelling than science. Science is everywhere in environmental policy formulation and legal responses. Ever since Rachel Carson wrote Silent Spring, science has been influencing environmental policy. As a matter of course, scientists uncover, identify, pose, develop ecological problems which need to be answered by regulation. They do take an important role in framing the environmental protection regulation. And last but not least, they get more and more involved in court practices as independent witnesses or as experts apprising the applicants and the defendants. Accordingly, scientific concepts do permeate environmental legal field. Biogeographical regions, hydrographical basins are indeed scientific concepts that oblige lawmakers to transcend boundaries between states, boundaries between regions, boundaries between international organizations. In addition to this, from a European perspective, courts, particularly at EU level, have been elevating science as a key, as a decisive criterion in order to adjudicate complex cases, in particular in the field of placing on the market hazardous substances. For instance, in a famous landmark Pfizer case related to the banning of virgianemissin, known in Australia or being used in Australia still today as an antibiotic growth promoter, in particular in chickens, for chickens. That substance was banned by the European Commission in 2001, and the company marketing the product, Pfizer, contended with the approach, the precautionary approach endorsed by the European Commission, lodging a case before the General Court of the EU. In that judgment, the court stressed that the scientific advice upon which the Commission has been banning the substance has been based on genuine scientific advice, and that advice was based on the principles of excellence, independence, and transparency. So far, this has become, ever since, settled case law at EU level. With respect to the authorization granted by the European Commission to the paraquat, which is a pesticide that has been widely used across Europe, that's known to be toxic, ecotoxic, and leading among farmers to the Parkinson disease. Though the hazards were highlighted, the European Commission decided to allow specific restrictive use. That decision had been challenged by the Swedish authorities before the General Court of the EU. The General Court really delved into the scientific issues and reached a conclusion that the Commission, in allowing the marketing of the substance, though for very specific uses, did not delve in all scientific issues, and in particular did not carry out complete throughout risk assessments with respect to the impacts on the pheasants, on the hares, and the rabbits. And that, as a result, led to the nullification of the decision. Since 2007, paraquat is prohibited within the EU. Another case in point is the ability for the member states to depart from the principle of free movement of goods. That's the linchpin around which the internal market resolves within the EU. The member states are allowed to bring restrictions on free trade of GMOs, hazardous substances, as well as waste, inasmuch as they are able to shed the light, thanks to science, on the environmental and health impact the trade in these goods is likely to pose. And accordingly, the Court of Justice of the EU, as well as national courts implementing EU law, are controlling the extent to which the national authorities are buttressing their decision upon scientific, genuine scientific analysis. Needless to say that environmental law, though it's drawing a lot of inspiration from scientific facts, is nonetheless a legal discipline or a technique for managing a social order that is capable of regulating conflicts with its own conceptual tools, which are not legal tools. Therefore, concepts from a legal perspective of species, subspecies, GMOs, substances, pollutants have a regulatory scope that do not necessarily follow the contours, the spheres of scientific definitions. And that's perhaps why scientists and lawyers might encounter some difficulties to understand each other. In my various articles and books on the environmental principles, I've been stressing a shift of emphasis that occurred in the course of the 1990s, where public authorities in particular within the EU have been moving from a traditional preventive approach under which the determination of environmental risk are acceptable in light of the relevant scientific data to a more innovative approach that have been qualified as anticipatory approach, where the environment is getting the benefit of the doubt whenever the link of causation or the extent of the damage cannot be clearly identified. I shall address in brief 5 issues. I shall comment upon firstly the model of prevention, which is the classical welfare approach in policy and law to deal with risks that are considered to be certain. I shall comment upon this shift of emphasis in allowing administration to take full consideration of scientific uncertainty in their decisions. I shall discuss on the third stage the threshold levels at which these precautionary measures may be taken. And fourthly, we'll discuss some of the tools that have been developed under EU law to enhance these anticipation models. Lastly, I will bring some food for thought regarding the implication of the principle of precaution. Well, this is a picture of Cartier-Bresson, famous French photograph. The picture was taken in a mining area in northern France, in Douai. And as a matter of fact, scientists will be able to assess the extent to which this pedestrian will get his feet wet, given that he's just jumping in the middle of the water. And maybe scientists will be able to reach a conclusion that there's a 100% chance that these pedestrians might be wet. And for lawyers, we will consider that that picture is falling within the ambit of this model of prevention of risk, under which the outcomes are clearly defined thanks to scientific analysis, and probabilities of the occurrence of the risk are known objectively and can be assigned to each outcome. And where something is scientifically certain, the principle of prevention or preventive action is coming into play, though there is still lingering uncertainties regarding the exact time and the magnitude of the occurrence of the risk. Is the pedestrian going to wet his shoes or part of his trouser? That's perhaps subject of debate among experts. Prevention is deemed to be a key political principle, but also a key international principle in the field of environment. I've been highlighting 2 key judgments in the environmental field that were handed down by the International Court of Justice. The first one deals with the contention brought by Hungary against Slovakia regarding the completion of the Gabčíkovo-Nagymaros dam on the Danube. The second one is more recent. It's a judgment delivered by the International Court of Justice 2 years ago regarding the application by Argentina versus Uruguay concerning the operation of pulp mills along the Rio de la Plata. In each of these judgments, the International Court of Justice has been stressing the duty of care, the duty of vigilance and prevention falling upon the defendant, and accordingly the defendant states is obliged under general international law to carry out impact assessments regarding the known risks that are entailed by the operation either of a dam or a pulp mill. I'd quote the paragraph 204 of the pulp mills judgment. The court is reaching the conclusion that the EIA requirement is considered to be part of general international law where there is a risk that a proposed industrial activity may have significant adverse impact in a transboundary context, in particular on a shared resource. And as a result, the duty of prevention, the duty of diligence, the duty of care is deemed to be infringed inasmuch a party does not conduct these formal procedural requirements. By the same token, another part of the environmental policy dealing with the hazardousness of products as subject to bans or to restrictions is also reckoning upon another technique to assess certain unknown risk, and it's known as the risk assessment based upon hazard identification, hazard characterization, exposure, as well as risk characterization. And these techniques allow the experts to calculate the magnitude of potential loss and the probability that the loss will occur. Accordingly, decision makers will be able to calculate the different pays-off entailed by any or every of the decision-making options. However, looking at the Northern Pole, the future of this polar bear appears to be somewhat compromised, to say the least. And unlike the pedestrian, the French miner we've seen in front of in Douai, this polar bear might not leap as he does in the future, perhaps in 20 or 30 years from now, with the vanishing ice cape. Given that scientific consensus is difficult to achieve, and I imagine that the majority of this audience is better placed than myself to understand this, politicians, decision makers have been keen on exploiting scientific controversies in order to postpone or to delay action in face of uncertainty. So uncertainty, to some extent, has become an excuse for the absence of action. Politicians are often retreating behind the veil of uncertainty to avoid to be confronted to hard political choice, hard economic choice regarding restrictions that could be placed on installations as well as on products. And that's where the precautionary principles comes into play, given that that principle allows the decision makers to tackle risks for which there is no definitive proof of either a link of causation between the suspected activity and the harm, or whether the suspected damage will materialize, or the extent to which that damage is likely to materialize. From a legal perspective, the principle is challenging and, as a result, has been dogged by controversies ever since. It's challenging on the account that it's calling into questions traditional legal system, most of which are permeated by the need for certainty. Criminal law, as well as administrative law, as well as civil liability law, are underpinned, indeed, by this holy quest that facts must be certain in order to adjudicate the case. And praised by some, disparaged by others, the principle is no stranger to controversy. In particular, that it's enhancing the leverage given to administration in tackling risks in the face of uncertainty. I would like to stress that the principle was prompted mostly in the course of the 1980s with respect to the Northern Sea, which is an ecosystem at threat. The German authorities were keen to shed the light on the principle, and ever since the principle has been enshrined in numerous treaties, revised treaties, protocols concerning a wide array of environmental areas. Marine pollution has really been the beacon of the principle. I've been listing here a number of agreements, international agreements that have been concluded in the course of the 1990s, under which the principle has been proclaimed. One will realize that all these agreements are covering pollutions in Europe. I've encountered very few agreements of that type for the Asian or for the American continent. By the same token, at the end of the 1990s, a number of agreements dealing with transborder river pollution were also adopting the principle as a key principle. Most of these agreements are framing the principle in such a way that it's deemed to be a binding principle. Nevertheless, because the principle is being applied in extremely varied concepts ranging from nature conservation to marine pollution, its formulation is likely to differ from one agreement to another one. A variation in terminology reflects the controversy taking place whenever these agreements are negotiated, and disputes have arisen in particular between the EU and the USA regarding whether precaution should be labeled or coined as a principle or merely as an approach. Needless to say that the American authorities have always been favoring an approach, given the reluctantness of the American legal system to embrace the concept of principles, whereas German, French, Dutch, Belgian lawyers have no problems whatsoever to apply principles, legal principles, in their daily practices. Of course, the proponents of an approach are taking the view that a precaution is not legally binding, it's just a guiding policy principle, but that does not entail any legal obligation whatsoever. I will stress that the International Tribunal of the Law of the Sea, in dispute settlement that has not been so much commented upon in international law journals, has been stressing that under the law of the sea regulations on the nodules and the sulfides that are likely to be exploited under fairly strict conditions, the principle of precaution has to be considered as a binding obligation, and even as a general obligation of due diligence of the states, which is even applicable outside the scope of these two regulations. So that means that clearly, in the eyes of the ICLOS tribunal, the precaution is under binding obligations, and the states wishing to carry the exploitation of nodules and sulfides are called on to abide by that obligation. However, given this wide array of agreements and conventions enshrining the principles, we are, as lawyers, fascinated by the amount of versions and the difference between the different conditions laid down under these definitions. I give two examples, one related to the OSPAR 1992 conventions on the protection of the North Sea and the North Atlantic. The definition gives really wide powers to the national authorities to apply a precautionary principle. The thresholds are relatively low, whereas under the Rio Conference on Environmental Development of the same year, 1992, the framers of that definition have been stressing the importance of cost-effective measures. So on the one hand, threats of serious and irreversible damages, whereas under the 1992 OSPAR conventions, a broad range of damages are likely to be considered. On the one hand, lack of full scientific certainty, whereas under the OSPAR conventions, no conclusive evidence is tantamount to a lower threshold, and cost effectiveness is not required as an absolute obligation under the OSPAR convention. So these two examples really highlight that a fewer amount of states with an environmental profile are likely to embrace a much more generous definition than 170 states in the course of a worldwide international conference. Other examples, that's a definition that has been highly influenced by the US diplomats, though they never became party to that international agreements, and they've been quite reluctant toward the Kyoto Protocol, as you are aware. Again, the framers, the authors of that definition, have been stressing the importance to achieve cost effectiveness and to cover exclusively serious or irreversible damage. Other examples can be drawn from fishing agreements. This is the 1995 FAO migratory fish stock agreement, under which the principle is enshrined in different obligations. But perhaps the most significant development occurred at EU level. The Treaty on the Functioning of the European Union, under which the different policies of the EU are carried out, are developed, contains an obligations regarding the environmental policy, and Article 191 reads as follows, that the EU policy on the environment shall be based, among other principles, on the principle of precaution. Accordingly, under EU treaty law, which is tantamount to EU constitutional law, this obligation is mandatory, though the EU institutions do enjoy some room for maneuver while carrying such a policy. As a result, different pieces of legislation such as directives or regulations, in particular in the field of food safety and GMOs controls, do contain expressly the principle of precaution. As a result, the national courts that have to comply with EU law, as well as the Court of Justice of the EU, have been applying in a great number of cases the principle of precaution. Moreover, even some constitutions in Europe do proclaim the principle. This is the case of the French constitutions. After very hefty debate, thanks to the interest of the former president Jacques Chirac, the principle was enshrined in the Charter on the Environmental Protection, though the scope of the principle is limited by an array, a flurry of conditions, and the language of that provision is rather obscure and confusing. Nonetheless, the principle has direct effect, so it's in a number of challenges before the French Constitutional Court, applicants have been claiming the infringement of that principle, though the ambit of the principle is restricted to environment and does not cover health issues. Whereas at EU level, the General Court and the Court of Justice see no problem to apply the principle to consumers issues, to food safety issues, and to health issues. So actually the principle is really gaining momentum in cases on GMOs, on food safety, much more than under the auspices of environmental law. That brings the questions whether some international court or tribunals could reach one day the conclusion that the principle has a customary value. This is an important fact, an important point on the account that many states do not provide for any legislations proclaiming that principle. In case court could reach a conclusion that's a customary international obligation, that principle could be applied by this court, though the bilateral or multilateral treaties do not provide such an opinion. So two conditions must be fulfilled. There is a repeated use of the principle through state practice. This is indeed the case for Europe. And there is a consistent opinio juris that's likely to transform precaution into an international customary norm. So my view is that most of the European lawyers are claiming that the principle is part of international customary law. So far, international courts have been quite reluctant, have been trying to avoid to answer that questions, like bad students in an oral exam, they've been trying to avoid to give a clear answer to that question. And the American scholars are just taking the opposite view, reaching a conclusion that so far there is no consistent opinio juris. However, the principle could have just a regional customary value between Australia and New Zealand, for instance. So though a specific environmental or health agreement between the two countries won't proclaim the principle, given a respective state practice in the two countries, given that most of the authors in both countries are reaching the conclusion that the principle is already at that stage an international tribunal adjudicating a dispute between the two countries could reach that conclusion. However, that will be much more difficult to apply such a reasoning for African states or South American states, given that there is just very few state practice regarding anticipation. Needless to say that legal international adjudication is quite tricky. International courts are afraid to dismantle or to reinterpret treaties between nations that have been entailing somewhat 10, 12 years, 15 years of hard negotiations between states. And in most of the judgments I mentioned, or I've been analyzing, the International Court of Justice or the International Tribunal for the Law of the Seas is calling for vigilance, for prudence, for caution, but does not expressly state precaution as a key principle to adjudicate the case. In the last case, the pulp mill case on River Uruguay, the International Court of Justice require full evidence from Argentina and has been rejecting all the Argentinian pleas on the account that they were not substantiated by clear scientific and indisputable scientific evidence. So this is an example of a case that was adjudicated by ICLOS. It was an application brought by Australia as well as New Zealand regarding an experimental fishing program of the endangered southern bluefin tuna in the southern Atlantic. That's a very highly prized commodity in Japan. Though ICLOS has been condemning the experimental Japanese program on the account that there was too much uncertainty regarding the evolution of the species. There was too much variability regarding the mortality of the fish, regarding the size of the population, regarding the level of production, the age of the reproduction of the tunas. The ICLOS erred on the safe side in requiring prudence and caution and in reaching the conclusion that the experimental program was departing from the obligations of the international treaties on the southern bluefin tuna exploitation. So, all in all, the question arises as to how the different states should apply the principle. What's the level of the risk? Is there an hazard? What's the level of exposure? So the question of thresholds are all the time coming on the forefront of the dispute. I'm giving here two examples, one drawn from an European Commission's communication on the principle that was adopted to assuage, among others, USA and Canada and perhaps Australia, on the manner in which the Commission was ready to apply the principle. There's much emphasis being placed on the examination of scientific developments. The idea underlying the communication is that precautionary measures are deemed to be provisional. They are deemed to be buttressed by a further scientific development. And in case that at the end of the day there is no confirmation by scientific experts of the seriousness of the risk, perhaps the measures should be abandoned. The second example is drawn from the Kellogg's case. Kellogg's are cereals, quite successful in Europe. I've not seen them in the Australian market. It was a challenge brought by the EFTA surveillance authorities against Norway, and the Norwegian food safety authorities has been endorsed a quite tough approach regarding its consumer protection. on the account that you have some iron in the cereals. The court in Luxembourg stressed that such a decision had to be based on the best available scientific knowledge, and that scientific knowledge should prevent the decisions to be either capricious or arbitrary. So there is still this ideal that genuine science, independent science, allows enhances the adoption of measures that are unlikely to lead to discrimination, to protectionism, to administrations behaving capriciously. Since the year 2000, the European Commission, as well as the OECD, have been copying the the US model in drawing a line between risk assessment and risk management. As a matter of fact, my view is that this line is constantly blurred. I don't think that scientists are able to work in perfect isolation, and risk managers, as a matter of fact, do also reckon upon further and further scientific evidence. But nonetheless, a number of communications, a number of judgments handed down by the Court of Justice of the EU have been stressing this ideal world under which, on the one hand, there is a genuine scientific approach with experts examining both the hazards and the risk, and that enable the experts, thanks to mathematical modelings, to calculate precisely the outcome, the probability of the outcomes. And then, on the other hand, the politicians that are called on to weigh under the constitutional law or under the Treaty on the Functioning of the European Union the antagonistic interest, protection of labor, protection of the environment, protection of health, protection of consumers, but also free movement of goods, free movement of services, the freedom of establishments of companies across the EU. And so one understands that political decision-making process are somewhat difficult given the wide array of constitutional obligations to take into consideration. So, risk managers are facing a difficult time, in particular regulating GMOs. The EU regulations on GMOs, but also on different pesticides, have been heavily criticized by some different of our trading partners, be it the Chinese, be it the Japanese, be it the Americans. And my view is that model is far from being perfect. Nonetheless, the court so far at European level have been reaching the conclusion that the risk assessment model is far from being perfect, that there must be a state at which decision makers, so the EU commissions or the Council of Ministers, must be enabled to err on the safe side in taking precautionary measures in limiting fundamental economic rights. So what are the implications of the principle? My view is that there is indeed a symbolic effect. The fact for the French government to call the constitution lawmaker to enshrine the principle in the constitution is not only an act of bravoure, but it allows the principles to stand at the top, at the apex of the legal hierarchy. And that has huge consequence because the principle can be applied in constitutional litigation. Perhaps of importance is that the principle can play a key role as a rule of interpretation, and as a result restrict other fundamental rights or fundamental economic rights. And in a number of judgments I'm commenting in my forthcoming Oxford book on the conflict between economic growth and environmental protection in Europe, I've been highlighting that in a number of cases the principle can allow court to interpret broadly general obligation and accordingly to interpret narrowly the derogations to environmental protection. So whenever habitats have to be regulated or whenever derogations can be granted for the use of different hazardous substances, these obligations are likely to be interpreted either broadly or narrowly, but always with this view pro natura, in dubio pro natura. In case of doubt, the obligations must be interpreted in such a way that the environment is on the safe side. By the same token, the most stringent regime must apply in case of doubt. So in case the administrations are deterring over applying an authorization procedure or a registration procedure, and the lines are quite blurred, are quite confusing in most of the cases, the courts are adjudicating that's the most stringent regime that should apply. Last but not least, this is the question of the burden of proof. That's perhaps the most salient issue. Nonetheless, the principle is only one device in a battery of principles. My view is that the European Commission and the Council of Ministers, as well as the European Parliament, has been failing to apply the principle of the polluter pays principles. So we are lacking clear obligations regarding civil liability, regarding eco-taxation so far, and that's a major mistake. Other principles are of importance, the rectification at source principle that's also recognized under EU law. But the principle of precaution is also conflicting with general rights, and particularly economic fundamental rights, or the principle of non-discrimination. So in allowing the French authorities to take a harsh stance towards some dangerous products, of course, the ways in which the French authorities apply the principle is likely to encounter the principle of non-discrimination or the principle of the free movement of goods. But one should perhaps not make a mountain out of a molehill. I know there is only one species of mole in this country, found in the northwest of Australia, which looks quite strange when I've been reading mammal guidebooks of Australia. In most of the cases that were analyzed in two books published by the European environmental agencies, cases ranging from fishery management to TBT to the mad cow disease to the ban of BBCs. The authors of these two studies have been reaching the conclusions that in 95% of the cases, the decisions in face of uncertainty or even in face of certainty are belated by 10 years, 20 years, 30 years. For instance, the dangers of asbestos were understood by English labor inspectors from the early 1920s. Asbestos has been banned in the EU only in 1997, and civil courts, be it in Germany, be it in Belgium, be it in France, are facing a wide number of litigation, civil litigation, liability litigation from families of workers who died because of the use of asbestos. So this is nearly a 70 years delay whenever there was scientific discussion. By the same token, there were already discussions on the impact of lead in gasoline that took place at Harvard University in 1932. in 1995, if I do remember, that's where we got a hugest increase of lead into gasoline. And lead in gasoline has been banned in the EU only at the end of the 1990s. So that shows the extent to which decision makers can delay decisions even in face of certainty. That being said, I still have more questions than answers regarding the status of the principle, its scope of ambit. Does it apply also to the private sector, or does it apply exclusively to public authorities? Does it apply exclusively to environmental sector? But then what are the borders, what are the frontiers of the environmental policy? That's an open question. And the manners in which these different thresholds must be interpreted is still dogged by FT debates. What risk assessment are we talking about? That will be the discussions of tomorrow morning. What's the taxonomy of uncertainty? What kind of evidence is needed? Who bears the burden of proof before the administration and before the tribunals? These questions cannot be assessed through the same lenses. Is zero risk or acceptable risk dealt with under precaution? Are the actions of the public authorities permissive or compulsory? And so on, and so on. So there will be still an ongoing debate in the countries in which the principle has been applied. In particular regarding the methodology and the different judgments I've been analyzing and commenting upon so far. The latest one delve each time more deeply into scientific reasoning. The last one was about the banning of a substance by the European Commission, Filiza-Resol, and there is a whole scientific explanation given by lawyers on endocrine disruptive perturbators. So that's perhaps not the end. As a matter of fact, there will be another session tomorrow morning that will allow us to learn from each other. And I'm very pleased to be able to hold a speech on this topic before this audience.